much. The music was good, but let's switch to, as I said, working mode. I hope you all had a good lunch break. Welcome to our afternoon panel on disruptive or enabling technologies, ethics, and the GDPR. My name is Mark Kohl. I'm from the Institute of European Media Law, and I'm very happy to chair this. I will only talk very briefly, introduce the speakers, but before I do that, I would like to point out you've got on your chairs, at least most of you, this flyer, because this is not the first time that the University of Luxembourg organizes a panel at the CPDP. We think it is an extremely important conference, and we have, by tradition, been working closely with our National Data Protection Authority in trying to identify topics that could be of relevance for the community. And at the university, we have a center which we call the Interdisciplinary Center for Security, Trust, and Reliability, so mainly in IT context, IT network context, and therefore we very often are discussing between computer scientists and lawyers legal issues about privacy, but also technical issues. And that brought us to the idea of today's panel, and I'm very curious because we will hear examples about actual technology, how it can maybe help in applying the GDPR, but we will also hear about how technology might go against the goals of the GDPR. And we will have 4 speakers, and at the end I will introduce to you the moderator. First speaker will be Mathilde Stenersen, to my very right. She is a legal advisor at the CNPD, the Commission Nationale de la Protection des Données in Luxembourg, so the national DPA, a DPA that has grown significantly in size in the last years. We have a couple of important also IT companies in Luxembourg, as some of you may know, and there is a challenge for the DPA to get ready also for the 25th of May, and I'm curious to hear about the technical help you are going to use for that. And I may say I'm also a little bit proud that she is here today because Mathilde was once a student at our university, and we started very carefully teaching when she was at the university also data protection law. Today it's one of our major areas of teaching that we do. Erik, I'm very happy to welcome as well. He's a partner at Stibbe law firm. For me, he's the lawyer that has been around on TMT, on technology issues, more or less ever since they're there, but definitely since the millennium change. He's led many key cases in the field. I think many of you know him because he speaks also regularly here. And he's got a lot to contribute also to today's question, not last because he's contributing to a commentary dealing with the articles on data security. Then we'll have Maja Brkan speaking after that. She's assistant professor in EU law at the University of Maastricht, also a very dear colleague that has been very active not only in EU law but in privacy law since many years. And we have several projects where we've been working together, so I'm looking forward to her insights. Finally, Charles Raab. I would have nearly said I'm not going to introduce Charles, but I want to do it for formal reason. He's a professorial fellow at the University of Edinburgh, but all of you know he's been one of the key figures in CRISP. And Charles has written an extremely interesting contribution together with Hilke Heijmans on data ethics, whether there is something like ethics in the GDPR, for a commentary which will be published this year, and therefore I'm looking forward to your insights. So apart from the speakers, we have Andra Giurgiu, who's sitting here next to me. She's a postdoctoral researcher at the SNT of the University of Luxembourg and has again been very instrumental for me in many research projects in helping to identify what are the real issues. She wrote her PhD actually on the forthcoming reform of the European data protection framework. The only disadvantage about it is it's Romanian, so I could never read it because I don't understand Romanian, and that's why I'm interested to hear how she's going to moderate our panel today. In English, I may say so. You have the floor.
Thank you very much, Professor Kohl. Actually, I would like to link to what you just said, that I've written actually part of my thesis on the upcoming reform, which means that, well, I've dealt with the legal issues for quite some time, and this allows me a little bit privilege right now to take the discussions from a strictly legal debate to perhaps a little bit more ethical, philosophical questions. Mainly I look at Professor Raab for that, but not only. The framework for this panel is actually, the basic premise is that technology can help enable fundamental rights, or it can actually disrupt their application implementation, the respect for fundamental rights. And we will show that while discussing with our panelists, for example, Mathilde, she will give, speaking about the tool that the Luxembourg GDPR developed, we consider it a very good example, a very positive example of how technology can be used to enable the protection of fundamental rights through guiding companies in the way that they should comply with the GDPR, a guidance which is much needed, and we see it every day when, I think we had this discussion also some days ago, companies actually want, many of them, they want to be compliant, but there is this, we have jumped over the awareness step. Everybody knows that the GDPR is coming. Now the question is how? And they're stuck to the very vague, very nice legal principles, and then they go like, but how do we implement them? Erik will look more closely actually into the technological neutrality of the GDPR, into whether we can argue that technologies can help in the implementation of the regulation, or contrarily, that we could say that technology is a barrier for technology-driven companies. Going beyond that, actually, we want to bring the discussion on a higher, larger level. Last year's CPDP, and I would like to remind you of that, was dedicated to artificial intelligence. It was the age of intelligent machines, right? As many of you probably still remember. More questions were raised there than answers were given. This is so because AI remains one of the biggest challenges to be tackled in the field of AI, not in the field of data protection and actually beyond. And the classical black box problem has not been dealt with properly. So far, we have heard of algorithmic accountability, auditability, transparency, and allowing human intervention. But this problem that actually falls under more or less Article 22 of the GDPR, this will be then addressed by Maja into more detail. And apart from that, even if we have like proper legal rules in place into how we should regulate the artificial intelligence and technology more generally, from the abstract level of the rules to their actual implementation, there is a huge step. And if we, going again back to the example of AI, we say accountability, but if we refer to an algorithm or a complex neural network, the problem is quite different. Even more so if we think about self-learning and self-improving algorithms, right? Which brings me back to the classical story of Asimov. I don't know how many of you know about it. I find it a fantastic short story that was written in 1956 already, and which takes place in a distant future, entirely run by AI. And you might say, why, we're in a legal conference, you make reference to sci-fi. It's not only me doing that, the European Parliament did it as well. I mean, if you think about a report on civil rules for robotics, whether we need civil rules for robotics, they actually refer to Asimov and the laws of robotics. And what I find absolutely fascinating in there is actually because it was mentioned in a report of the European Parliament, improve AI, develop AI, regulate AI, but at the problem of consciousness of AI, we should stop. And now I'm wondering, where is the limit to sci-fi and reality and legal rules? But it's not only, so before going, it's actually what we want to do here is to also underline the fact that we don't have all the answers yet, but what is very important, and I hope that this pointer is, yep. Yes, what is very important is for us to still phrase the questions. Even though we debated AI and technology intensively at CPDP last year, we can by no means say that we have answers. We have guidelines, we have explainability, accountability, transparency, and so on. We're discussing more and more about algorithmic auditability and so on, but we still don't have the ultimate questions. So what is important probably is to lift the questions now, to ask them rightly, they say for somewhere in the future. Well, we hope that it's not in the faraway future, because I don't think that we can wait so long. And who said it actually, I intentionally didn't put the name there, but probably many of you already know and have heard of the famous Rainer Maria Rilke. It's a beautiful quote, and I think that it fits very well into the type of discussion that we are having today. Going beyond that, actually, it's coming back to the strictly legal discussion, it's actually the CNIL that had intensive consultations on AI. They published a report, and they asked a very interesting question. How do we outsource our tasks to machines, and we want the tasks to be done by machines, the decisions to be taken by machines, but we don't want to take the human out of the loop, how do we do that? And they raise another interesting point, that the impact of AI is not only a personal one on the individual, but it has a very strong impact on us. It has a very strong collective effect, and this is something that we need to take into consideration, because it is clear we cannot stop innovation. We should probably not even try to do that and go into that direction. And actually, I was thinking, okay, so what is the added value, or how do we deal with ethics? We have brought ethics to the discussion, to the table of discussion. What did it change? I dare say, not much. I mean, from my point of view, feel free to contradict me later on. I would say not much. But what it has helped us actually is to actually put the problem into perspective, and actually hope that in the future we will have better questions, and we will be able to formulate them better in order to be actually able to come up with adequate and proper answers to them. And I would like to also underline at this point that, as always, as I see the discussion, is not always we have the beautiful framework for beautiful or not, it's arguable, fundamental rights and so on. And there's always we should protect the rights of the individuals, but we should allow the free flow of data. We had right here a discussion at the opening of CPDP where, you know, we heard how this legal framework that we have come up with is a great element for protecting fundamental rights, how we have strategies, how we have plans, how we are having transatlantic dialogues and so on. And then some, privacy activists were, yes, but we have this rule which is actually still not respected. We have this problem which is still not dealt with. So I will not delve into that discussion, but actually go on and saying that we have to look at the bigger picture. And when we talk about freedoms and liberties, is not about just individual freedom and whether my email address is protected, whether my name is protected, and so on. It's not only about if we have a data breach, will somebody steal my identity, or will then my bank details be compromised, and so on. I think we're talking about liberties and freedom. And also, I really like the way that this question was phrased. It's a place where the human spirit, will it still be a place where the human spirit can be cultivated and deepened? And questions, we would like to use question as a tool as civic tools in order to be able to set the premises for coming up with the right answers. And this is, at least from my side, the brief, brackets, which were not so brief, for setting the stage. And hopefully we will hear more to enlighten this discussion from our contributors. And with this, I would like to give the floor to Mathilde.
Hi, good afternoon, everyone. I'm just going to see if the pointer works. Yes. So my purpose on this panel today is to present an example of what Andra referred to as a technology enabling the application of fundamental rights, more specifically the GDPR compliance support tool that we, the CMPD, have been developing alongside the Luxembourg Institute of Science and Technology, and that we're making available with Digital Luxembourg and eProceed. So to present this tool, I'd like to go through the goals, the objectives that we have with this tool, thereafter talk about the setup and the functionalities of the tool, and finally the limits to the use of this tool. So before talking about the goals of this tool, I want to talk about thoughts that the CMPD had. So we at the CMPD, alongside a lot of other actors as well, have noticed that there are certain misconceptions about the GDPR. There's a lack of understanding of what the GDPR is and what it's meant to do. There's a lack of understanding of what the scope of the GDPR is, who it applies to, what it applies to, and when it applies. And there's also a general sense that it's a very dense text. So one of our primary objectives of this tool is to raise awareness of the GDPR and of its requirements, and also to provide the text and the requirements in a more accessible format. And finally, we want to provide guidance of how to understand the GDPR and how it could be complied with. And in doing so, what we want to do with this tool is to enable controllers to carry out an evaluation of their own activities compared to the requirements of the GDPR. So let them carry out a self-assessment of what they do with their data and how that stands up to the requirement of the GDPR, so that they, in that way, can identify areas for improvement and areas that need specific attention and areas where change is really necessary. And to do that, we want to take the theory of the GDPR and develop it into an operational tool. So put it into practice, really, by helping the controllers carry out their internal reporting for data protection and also helping them with the governance of the data life cycles. And we want to make sure that this is an encompassing tool, so that it's not just going to be a tool that is used by the legal department of a controller that sits down, looks over the GDPR and tries to fill it out. We want the controller to involve all the different business streams, so that every single department and actor that is involved in a processing activity contributes to the understanding of that activity and also contributes to making that activity comply with the GDPR. To provide the guidance, what we want to have is an evolving knowledge base. So we'll be updating the content of the tool with the opinions and guidelines of the Article 29 Working Party and the future EDPB, with national guidelines and administrative decisions, and also with national and EU case law. And finally, what we'd like to do in the future is take the generic model of the tool that we have now that applies equally across all sectors and develop it further to create sector-specific models that take into account sector-specific requirements and recommendations for that sector. For example, taking out the health sector and saying there are specific requirements here and there are specific recommendations for this very sector. Having looked at the goals of this tool, I'll quickly look at the three main components of it. So we've got the requirements framework, which is the GDPR that we've taken out and separated into different requirements, added questions that will allow controllers to reflect on these requirements, and also recommendations. All of this we've packaged into the assessment interface, which is where controllers, they then confront these requirements and assess their own activities. They can attach comments to the requirements. They can respond to how they consider if they comply with a requirement fully, partially, not at all, or if it doesn't apply to them, or if they haven't even thought about it in the first place. They can also chat internally and add references of documents that prove how they comply. The final component is the dynamic reporting that graphically represents to the controller their use and their completion of the tool. Delving further into the requirements framework, we've split it up into three different parts. The first being a part relating to organization. For the organization, we've included general obligations of the controller. Included in here are the obligations relating to the record of processing activities. We've got general points for the rights of data subject, such as the requirements to provide information in a clear and legible manner, how this is complied with, how the deadlines for responding to data subjects' requests, and also the requirements that relate to data protection officers and data breach notifications that apply globally across all the processing activities. In our second part, we have the records of processing activities that allows the controller to evaluate each single processing activity and each requirement for that processing activity. So requirements relating, for example, to joint controllership, to principles and the lawfulness of the processing, and also to the rights of the data subject for that specific processing. And if it applies as well, requirements that relate to the DPIAs, transfers to third-party countries, or the use of special categories of personal data. All of these aspects can be evaluated for each different processing activity. And the final part, part 3, is that on processes. Here again, the controller can carry out a self-assessment, a self-evaluation of the processes and whether the processes satisfies the requirements of the GDPR, and these processes can then be linked to one of the processing activities. To give an example of the requirements framework, I've taken the right to data portability. So as you know, a data subject has the right to receive the personal data that have been provided to a controller to transmit it to another controller. The processing is based on consent or a contract, or the processing is carried out by automated means. So what we've done is we've taken the article of the GDPR and we've created the requirements based on that. Within the tool, the controller is then faced with this requirement and has the full text of the GDPR available as well. So not the abbreviated version that I've shown here on the screen for the purpose of today's presentation, but the full text of the GDPR. And to give the guidance, we've then taken the guidelines that have been published by the Article 29 Working Party and set out the points as possible criteria to meet the requirements of the GDPR. So what we've said is that information should be provided relating to the right to data portability when the data are first collected, that the data subject should be informed about the difference between the right to data portability and the right of access, notably in terms of what data will be available. Also, that the data subject should be informed again about the right to data portability before the closure of the account. So we've taken all the points that are listed within the guidelines and we've included them here as well. The controller can then see all of these requirements and self-assess which ones are used and then just determine themselves whether they consider that they comply with these requirements. Again, we've noted that there are possible criteria to comply because even though they might say, yes, I have done all of these, if they don't do it in practice, they won't actually comply with the GDPR. So now, having looked at what our goals are for this tool and also what the different components of the tools are, we'll look at the functionalities. So what we want to have is a logical and detailed approach to the GDPR. At the moment, what we've got is a set of more than 350 requirements and recommendations that are, of course, continuously evolving and continuously updating with each new set of published guidelines and opinions. We have a dedicated evaluation for each part of the controller, so the part 1 can be separated into each department or site of the controller, can be carried out globally for the controller. There's a separate evaluation for each processing activity and for each processor. The tool is also meant to allow controllers to set up, edit, and manage the record of their processing activities, and also manage the supporting documents. So they can say whether they consider that they comply with a requirement, and if they want, insert the reference to the document or procedure that they consider proves that they comply with this requirement. They can also comment the answers given where they say, we consider that we fully comply with this, and then add comments as to why they consider they fully apply, or they can say, we consider that this requirement doesn't apply to us at all, and then comment why they consider that it doesn't apply. For example, for a DPO, they could say, well, we're not going to fill out the part on DPO because we consider that we don't need to name a DPO because reason 1, 2, 3, and 4. There's also the possible of an internal chat, so one department could leave a comment for another department stating, I think this department should add or complete this answer. The final aspect is the possibility to export the assessment in an Excel format and carry out the assessment offline and then import this assessment back into the tool afterwards. Now, as I said, it's a continuously evolving tool. We're still working on it, and we will continue to work on it. So we've already identified aspects that we'd like to include in a 2.0 version. For example, the possibility to import and store the supporting documents that prove that the controllers consider prove compliance, rather than only include references to the documents. There are limits, of course, to the use of such a tool. The primary one being that it is a compliance support tool. And it is also made clear at the use of this tool that the very use of the tool does not guarantee compliance with the GDPR. If we look at the tool in a most simplistic format possible, it is a multiple choice questionnaire. If every question is answered, that doesn't mean that the questions are answered right. As I said, it is a self-assessment tool. We provide the requirements. It is up to the controllers themselves to assess whether they have considered the requirement, whether they consider they partially, fully, not at all comply with the requirements, and also why they consider that they comply. It is a purely self-assessment procedure. Also, the controller remains responsible for managing their processing activities. The principle of accountability is not affected by the use of such a tool. The tool is also not to be considered as a solution to all of the challenges that are presented when data processing is carried out. It is not a be-all and end-all of solutions to data protection questions. And finally, the CMPD does not have access to the data that is being put into the tool. So it is not a direct line of communication with the Data Protection Authority. It is not a question of, I have put this in to the tool now. Hello, CNPD, do you think that this is sufficient? That is also not how the tool works. Again, I reiterate, it is a self-assessment tool. Now, as I have a limited amount of time to talk, I'm still in the time almost. Instead of going through the interface, I will give you the link to the interface. This is where the tool can be found. You don't have to write it down. You can also find it on the homepage of the CMPD, which might be easier. I'd like to point out two aspects. The tool is currently available from Belgium, France, Germany, Switzerland, and Luxembourg to allow us to manage the workload. But we are already working on making it available to other countries as well. Secondly, the content of the tool is in French, because the legislative language of the Luxembourg, that is the language of the legislation, is French. With these two caveats in mind, I invite you to have a look at the tool. Thank you.
Thank you very much, Mathilde, for this excellent presentation of the tool developed by the CNPD. I think it's quite interesting, and I think it's a very good example of how technology can be used as an enabler. I would have many questions, and I will just pass. And to give you some explanations actually about how we plan to organize everything, after the first two presentations, we would like to actually open the floor for questions from the audience. And to the extent that there is time, I would just pass a question to you to just dwell on until we open up for questions. For example, I was wondering, you clarified very clearly that it's not the tool it doesn't guarantee any compliance, which is excellent to make clear as a statement. But also I was wondering about the dynamic character of the tool, how the updates take place, how regular, and by whom, whether you have a dedicated team within the CNPD dealing with that. But for now, I would like to give the word to Erik and look forward to your presentation.
Thank you very much, Andra, and thank you to the team of the University of Luxembourg for adopting me on this panel. Whenever I go to Luxembourg for some teaching or for an event, I always feel part of the family, so thanks for continuing that tradition. Also, thanks for starting off with the quote of Rilke, because it reminded me a little bit of the luxury that I have today in dealing only with questions, which is quite, let's say, the opposite of my daily work as a legal practitioner, where I don't really have a lot of time to ask questions, because most of the time questions are being put to us and we are asked not to answer at some distant point in the future, but rather immediately and very concretely. So this is a great exercise for me. At the core of my practice, it's really about interaction between technology and the law. Everything we do in terms of the projects is about how law and technology go together, whether it's in litigation, advisory work, or it's in drafting contracts. And if I apply that to the GDPR as a body of law, a body of rules, then there are, to my, how would I say, feeling, a lot of points to be made about this interaction between the rules that you find in GDPR, the provisos of the body, and technology. And the idea for me in this contribution to the panel was to actually point out some of these interactions, different dimensions, and I wanted to do that by using 4 statements, by putting forward 4 different statements, each of them tying into a dimension of the interaction between technology and the GDPR body of rules, and pointing out under each statement what the kind of relevant points are that you would find either in support or against the statement within the GDPR. To demystify that a little bit, I will simply go to the first statement, assuming the technology follows. Yes. The GDPR is a technology-neutral regulation. These are statements that I either have picked up at other conferences or reading materials about GDPR or reading in the GDPR myself. And I think there is clearly support within the GDPR to say that this would be an acceptable or a reasonable statement. First of all, there is the recital 15 of the GDPR, which underscores the technology-neutral objective of GDPR in terms of protecting the rights of natural persons, which would go in favor of the statement. Also, if you read the GDPR, there is hardly, and I underscore hardly, any reference to specific technology types or types of technology. There are some references to technological developments and the relevance of developments in the future, and the fact that these developments on an ongoing basis need to be factored in the way companies, controllers, processors need to comply. For example, in recital 26, there is the reference made to the way that the possibility to identify natural persons will be treated will depend on technological developments. So that's a way of ensuring that whatever the technology is at one point in time, it will be relevant for applying the GDPR. And also, obviously, there is the privacy by design set of obligations in Article 25, which also kind of ties into whatever the state of the art and the level of technology development will be at a given moment in time. At the same time, we also find other sounds and other reference points in that body of rules. For example, in Article 97 of the GDPR, there is to some extent actually an admission of the fact that the technology-neutral character of GDPR is not complete because there is a clear mechanism in there that will allow and will require the Commission to propose amendments to the regulation, including in order to accommodate changes in the technological developments. So that, to my extent, is an acknowledgement of the fact that technology neutrality objectives have their limits and will need other mechanisms to complete them. Also the fact that there are explicit references to points like pseudonymization and encryption. Today, that makes a lot of sense to us because it's kind of run-of-the-mill. It's something that's heavily debated, but the question is whether within 10 or 15 years, those terms by themselves will still make any sense. By the way, my personal opinion is that technology neutrality for any piece of legislation is a myth. And it's a myth because we can only write laws based on what we know. And we are conditioned by what we know and what we have experienced as humans in terms of our interaction with technology. And on the other side, we cannot anticipate on what we don't know. Obviously, you have people who call themselves futurists, but still, we can only rely on them to the extent that they know something and then embody that. So for me, those are intrinsic limitations to the possibility to be technology neutral in the way we make laws and regulations. Going to a second statement is the one that deals with the need for new technologies for proper implementation of GDPR. Obviously, the presentation just given by Mathilde underscores the kind of interaction between technology and rules at the level of having tools available, bringing tools to the companies concerned. And it's clear there again, we find support in the GDPR that there will be a need for new technologies to properly implement it. Today, we know that a lot of the technologies that have been used so far, they privilege what I would call data capture over data security. And that's a big problem, especially if you look at obligations that are like privacy by design, where you need to make sure that the technology itself complies with the requirements and that the process is in accordance with. So that is at odds with, I think, the way a lot of technologies have been set up so far. Also, if you look at the recital 68 of the GDPR, there is clearly an encouragement for data controllers to embed, to integrate, to involve new technologies, to develop the necessary formats to deal with the data portability right. And other individual rights given to data subjects will require additional technologies. Think about the right to be forgotten, and the fact that the only way to provide a comprehensive set of information back to a data subject asking for access, for example, or information, will be to have technology in place that allows for a kind of efficient and effective search of information on that data subject within the organization, have a centralized approach to the correction of any data that need to be corrected across the board, and not, for example, have what we call a spaghetti landscape within your IT environment where you have 12 or 15 databases that are not properly connected and don't have a common layer. On the other side, there are indications in GDPR that there may be not such a dramatic need to invest into new technologies, and that using the currently available technologies would be sufficient. For example, in certain recitals, reference is made to the criterion of available technology, which means that's what is existing today and not what exists within 5 years, or not necessarily what is kind of new, but maybe just kind of already embedded and tested technology rather than the fully perfected new rules out there. It is also clear that the GDPR does not require anything impossible. Now, there is already a kind of general rule, which in French we would refer to as à l'impossible nul n'est tenu, but that's also explicitly embodied in GDPR. There is always the kind of balancing of this objective to protect fundamental rights on the one hand, and also on the other hand the freedom to conduct a business and to be kind of proportionate in the way the two need to be reconciled. And also the fact that ultimately the goal of these rules, and this is already the case obviously with our current data protection directive, is not the protection of personal data per se. This is actually a tool towards a internal market and a free flow of personal data. I would want to go to a third statement, which I've often heard and picked up in discussions, which says GDPR is an obstacle for technology-driven companies. And there is something to be said for that. If you talk to companies who are involved in blockchain technology, for example, in big data solutions, or even in artificial intelligence, they today are kind of complaining about GDPR, and they find it something that prevents them from doing their business. Other companies are pointing out the cost of compliance, and they see GDPR as a hindrance for their projects. And other companies are facing with a lack of knowledge internally on how they can actually turn their data that they already have collected into a viable business model, considering restrictions and requirements of GDPR. Also, there are significant administrative burdens imposed by GDPR, so there is something to be said about how the GDPR actually would make the lives of these companies a little bit more difficult. On the other hand, and that's something that we also try to point out to our clients, there is clearly the fact that one of the key goals of GDPR is to facilitate the information economy within our European market. And in addition to that, the fact that if a company achieves a reasonable level of compliance, this will actually create new business opportunities. Companies who are investing in compliance will also be able to profile themselves as being compliant, and they will be able to reap a benefit from that because they will be actually better off than, for example, a competitor who does not have the same level of compliance, which obviously kind of presupposes one additional thing, that is good information about the state of compliance of companies at a given moment in time. And then maybe the side question is, how will we organize that? But that is something we can debate and discuss a little bit later in our panel. In the interest of time, I will move to my fourth and last statement. And that's something that I've picked up a lot interestingly enough, also in discussions with representatives from DPAs, and that is, it is the practice responsibility to come up with practical solutions for GDPR compliance. To some extent, we can say yes, it's a fair statement, because the provisions of the GDPR and even recommendations of DPAs, even Article 29 Working Party guidance, to some extent are still vague, and they are still leaving a lot of room for interpretation. So we will need some practical translations, and we will need some tools, and we will need some creative solutions coming from the practice to deal with that. This is also further reflected in the GDPR, which allows for the development of codes of conduct. A lot of companies seem to be waiting for codes of conduct to arise. Often we actually tell our clients, listen, why don't you identify a number of your competitors and talk code of conduct and come up with something even before a DPA takes the initiative, or even before some overarching organization would invite you to do so. So there is room there to use that tool and come up with practical solutions to fill the gaps that are there. And the same can be said for the certification mechanisms or the seals that we are actually at some point expecting to appear in practice as well. At the same time, it's clear that it's not just up to practice to come up with the solutions. I think there should be at least some kind of and role to be played, the practice, the DPAs, the different advisory bodies that can play a role to work together and come up with solutions that pass muster. There's also clearly support for that in the GDPR, where, for example, in Article 57, the DPAs are invited to also monitor all the technological developments and make sure that they provide guidance based on new developments. So we are very kind of interested in seeing what will come out of that. And also the fact that there will be an ongoing dialogue actually with the DPAs on what the best practices are, and that's something that the industry clearly expects. To conclude, for me, coming from practice, there is a clear tension field between GDPR and the technology dimension. It's clear that there are plenty of pitfalls, but also opportunities. And I think the opportunity side is something that we should grasp and we should use to make sure that there is as much clarity as possible developed in a good interaction between the different stakeholders, including the data controllers, the processors, the DPAs, and the practitioners. The question is, how will we do that? I think we will have a big need for hybrids. And when I say hybrids, I mean people who are both savvy in law and IT. I think that's going to be a very big part of the puzzle and the solution going forward, in addition to the dialogue mechanism that I already pointed out. I think some of the concerns that I've pointed out are also fully present in the other privacy body that we are expecting, which is the e-privacy regulation. I have some examples of those provisos as well, but that's something I will reserve for the further debate. So that being said, I thank you for the time that I was allowed. I was hopefully able to respect it, and will happily hand over to Andra.
Thank you very much. I think always the main challenge comes up when we want to engage the audience, and this is why we don't want to leave it up to the end. So we would like to actually open up the floor for questions at this point. But before we do, I have just a very brief comment. I think that when we talk about GDPR tools, there is a big risk that we have very different approaches. Lawyers would be like, whoa, 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 stop, verify, check all the legal rules, and then design. IT specialists, they design and then they fix the bugs. And this is where there are some problems that come up. There are many IT specialists that come up with GDPR tools, and I've seen quite some that pretend to talk about data subjects' rights, about consent, and so on. And when you take the tool apart, it's an empty shell. And then the problem is that the law running after technology in order to solve these problems and to point out that there are problems, it's very, very difficult if we start using and selling these tools as GDPR tools. But that being said, we would take 2 questions from the audience at this point. Yes, please.
So my name is Aurélie Pols. I'm a hybrid independent. Thank you very much for your interventions. They were really interesting. And talking about this idea of hybrid, I would like to hear your thoughts about public and private partnerships. Maybe some ideas around that.
Okay. Shall I start off, or?
I think so.
Yeah. Well, public-private partnerships could be a solution to creating hybrids, or to, in a next step, to make sure that they can play their role. I think a well-thought-out model of partnership between public entities and private sector would be able to create solutions, but I think the challenge is much broader than that. It's not just in the interaction between public and private. I think it's really about making sure that in the education there is sufficient attention created for the other relevant domains. For example, I studied law, but I also studied IT management later on. In my law career, in my curriculum, I never had any kind of connection point with IT. And I think actually my kids, being much younger, never had any real privileged contact with IT as part of their schooling. And I think the more and more our society becomes sophisticated and digitized, I think the more we will need hybrids to kind of understand the complexity and come up with solutions, whether it's GDPR or anything else. And then I think that a government that, for example, would take some initiatives in combination with private practice using PPP, I think would be welcome, but it would just be, I think, one layer of something broader that we would need to set up.
One more quick question, yes, please.
Thank you very much, Marianne Karza from the Commission. Actually, to Ms. Stenersen, I would like to ask you, because in Luxembourg there are many multinational companies settled, which has already their own corporate binding rules. Yeah. So when the GDPR compliance will be monitored by the DPAs, how to assess these corporate guiding rules, how it should be conformed with the GDPR? Because it's not only the GDPR compliances, but definitely it's an assessment of the corporate internal rules of a multinational company like Amazon, who is processing worldwide customer data. So this is one. The other is a remark for the code of conduct. I'm afraid that elaboration of the code of conduct under Article 40 of the GDPR, still the process is not really very fixed of the approval of the code of conduct. So I wonder that do you have already some ideas about it at academia level? Thank you.
Mathilde?
Yep. So if I understand your question correctly, you're asking how we as the small Luxembourg DPA intend to assess the compliance of large multinational companies with the GDPR. As per the establishment, well, the thing is that that's where the consistency mechanism of the regulation comes into place, because if other data subjects are concerned, or if it's a transborder processing, then other DPAs might be concerned DPAs as well, so it will no longer be up to exclusively Luxembourg to decide on that measure.
Thank you very much, Mathilde. And if you don't mind, we will keep the second question for the very end, because we don't want to take up too much time, and give the floor to Maja. Please. Yes, pointer.
Thank you very much, Andra. And of course, thank you very much to Luxembourg University for having invited me. We have collaborated already on other projects, and I'm always excited to collaborate with you. So I will speak today about explainability of autonomous decisions, and I have deliberately used the term autonomous instead of automated, which is used in GDPR, because my colleagues from computer science constantly tell me that automated decisions can be any decisions, even those which are not based on the algorithm. So an automated decision would be, for example, 1 + 1 is 2, whereas an autonomous decision would be a decision based on algorithm. So, and as you know, usually when you get some advice about how a good presentation should look like, they always say, well, you should always start with a joke. Here it goes. Oh, okay, sorry, I'm looking at two screens. So this was supposed to be a joke by computer scientists that an algorithm is a word used by programmers when they do not want to explain what they did. However, if you think about it, you might think, well, is this actually a joke? And this is what I would like to address today in my presentation. So before going into the technological and legal aspects of autonomous decision-making, I would just like to remind you how pervasive autonomous decision-making is in our everyday lives. When we go to the bank, our credit score is determined by algorithm, same for the insurance companies. Public sector is increasingly engaging into decisions by algorithms. For example, tax authorities and customs authorities are increasingly allocating or determining tax according to the algorithms. High frequency trading on the stock market, and businesses, especially big businesses such as Google, Amazon, Facebook, and so on and so forth, are using autonomous decision making in the framework of what they call business intelligence in order to take strategic decisions, profile their customers, or predict customers' behavior. What has also been discussed is the use of autonomous decision-making for judiciary, and this is a problem which arises mostly in US for the moment because, in my humble opinion, the directive and the GDPR would not allow for the moment for such judicial decision-making. You might have come across the example of Erik whose prison sentence was determined by system Compass. Then US also uses this other system called Valgaeren to determine which geographical area is more prone for certain criminal offenses. And there are, of course, answers in the press to that this should stop, but I think it is already too late to stop such decisions once they are in place. So I would like to talk today about explainability, and explainability has two facets. One is obviously a technological aspect, and the other is the legal aspect. Is there such a thing or such a requirement as explainability in the GDPR and in the directive? But to turn things around a little bit, I would like to start with a technological problem. And just while I'm speaking here, my colleagues from business school and from the Department of Knowledge Engineering are pitching their ideas at Maastricht University in order to obtain funding for a project that we have prepared together on the question of how we can ensure explainability in technological terms. So the idea behind this project is to create a classification of algorithms from the least explainable one to the most explainable one, and then to see where businesses could draw the line and make a trade-off between an algorithm which is still complex and allows for high performance, and the requirement, the potential requirement of GDPR for explainability. And I very much agree with Erik that there should absolutely not be any obstacle for technological development on the part of law, but that technological development should go as far so that it will be able to respect the law. So we should try to address this problem of black box algorithm through technological research. Currently, for example, the neural networks already you can see, you can determine sort of a saliency map where you determine where neural network is paying attention. And also there is research that has been done on quantitative input influence, which also determines which factors were more important and mostly taken into account by a particular algorithm. Now, from the legal perspective, I will not go into the question of automated decision-making in the framework of GDPR and the directive, because this is something that I spoke about last year. I would like to talk specifically about the possibility of the right to explanation. And as you might be aware, the right to explanation is, for the moment, nowhere in the actual text of the articles of the GDPR or the directive. It's not in Article 22 or Article 11. It's not in the articles on the right to access or right to information. However, there is one little provision hidden in the recital 71, which corresponds to recital 38 of the directive, which states that the data subject does have the right to explanation of the decision reached. And in my presentation, I'll go into the question also of the legal value of this recital and into the question of how we could potentially construct the right to explanation. Now, Article 22 only states that the controller has to provide certain safeguards to the data subject. And these safeguards are obviously the safeguard of human intervention, the safeguard of data subject being able to express his or her point of view, and also to contest the decision. Especially this right to contest this decision is a very important trigger which would potentially trigger the possibility of right to explanation. Now, these other articles on right to information and right to access require the data subject to be able to obtain meaningful information about the logic involved. And the Data Protection Working Party recently issued an opinion on this automatic decision-making, where it stated that that means that the controller should find simple ways to tell the data subject about the rationale behind or the criteria relied on in reaching the decision, without necessarily always attempting to explain a complex algorithm or to disclose a full algorithm. And this is something which in itself does not yet create a right to explanation, but then if you look at other provisions of GDPR, GDPR requires a high level of transparency. It requires that the info to the data subject is concise, easily accessible, understandable, and that the data subject is informed of purposes of processing. So there has been quite a legal battlefield among different scholars, scholars from Oxford Internet Institute, Wachter, Mittelstal, Faridi, then Edward Zweil, Mendoza Bygrave, who all sort of disagree to a certain extent whether the right to explanation should be recognized or not. And I'm more on the side of the scholars who claim that there should be such a right to explanation for at least 3 reasons. The first reason is that the right to contest and to challenge the decision given to the data subject by Article 22 would be a completely dead letter on paper if the right to explanation wasn't there. This would be similar to a situation where you would get a judgment from a court without stating reasons, but you would still have the right to appeal. How could you possibly appeal that decision if you don't understand why this decision has been taken? Secondly, an argument has often been stated that Recital 71 has non-binding value, and that it shouldn't be, not too much should be read into that article. I would like to point out that it seems to me that Article 22, by leaving out this express right to explanation and by letting it in through Recital 71, was a clear political compromise, and that the legislator did not want to have a final say on the question whether there will be no right to explanation, because in this case, the right to explanation wouldn't be there in Recital 71 either, but that it wanted to leave the last word to the Court of Justice, which then has a difficult task to either construct this right or not. And Court of Justice, as we know, is a very activist court, and it often takes into account the recitals, despite the fact that they don't really have a binding legal force. Then also, if we go again into the nitty-gritty lawyer's reasoning, we can see that Article 22, paragraph 3, which talks about safeguards, allows for other safeguards other than those that are stated there. So it states that data controller should provide at least for those safeguards in paragraph 3, which does obviously not exclude the right to explanation. And the right to obtain information about meaningful logic involved, there has been an argument that, again, a very legalistic argument, that this right to obtain an information meaningful logic involved has no link with safeguards in paragraph 3 of Article 22. That, again, is not true, because the meaningful logic should be provided at least in cases of Article 22.1 and 22.4, which means that it can also be provided in cases of 22.3, which talks about safeguards. So the methodology that I propose how to get to this right to explanation is to read all of these provisions together. And this is something that is similar than what the court has done in Google Spain, where it used the right of access and the right to object merged together in order to create the right to erasure or the right to be forgotten. So what I propose is that the court, when deciding a case on the right to explanation, should decide that Article 22, read in the light of Recital 71 in combination with Articles 13, 14, and 15, should be interpreted in a way that they give the data subject the right to an ex post explanation of an automated decision. And if that shouldn't be accepted, then I argue that at least when it comes to the sensitive data, such right to explanation should be recognized. For example, when it comes to medical data and medical diagnostics, where increasingly automated decision is being used, then a patient, I believe, should know about the reasons of why certain diagnosis was followed rather than the other, just as the doctor would have provided her with such reasons. And also, if the processing is done in public interest, if processing of sensitive data is done in public interest, in that case also I believe that there should be a right to explanation, especially if the sensitive data process is, for example, religious data or data about whether somebody is homosexual or not. And we can all remember the Qadi saga, where a Qadi who had according to him, no connection with Taliban's, was included into that blacklist where his funds were frozen, and then required explanation from the commission. And because that explanation hasn't been given, the court twice struck down the decision of the commission, and it twice said that the fundamental rights of Qadi were violated. Okay, then just for the end, I have prepared a little quote which urges us to study more about these issues from Mark Cuban, an American entrepreneur, who said that whatever you're studying right now, if you're not getting up to speed on deep learning, neural networks, etc., you lose. We are going through the process where software will automate software and automation will automate automation. Thank you very much for your attention.
Thank you very much, Maja, for your presentation. I think that, as you said, explainability also is to some extent part of the GDPR, especially read in the light of the principle of transparency and also notably accountability, but also perhaps just as food for thought, it's maybe we should think about more what we want to explain, because in the end it's not about transparency of the source code if we don't understand what to do with it. And with that, I would like to give the word to Professor Raab, who will give a couple of remarks and some put the discussion into perspective with regard to ethics.
Thank you very much. Is that all? Yeah. Thank you very much. In view of the time, I think we have about 8 minutes before the bell tolls for us. I'm not going to give the presentation that I had prepared because there really isn't time to do it justice. And I think it'd be much better if there were questions from the floor and discussion about the very interesting presentations we've heard. But just to say that if anybody wants to read what I've prepared, just please get in touch and I'll send you a copy of it. With that, I just want to say 1 or 2 remarks. What I would have said was that what I'm trying to talk about in my presentation is the relationship between law and ethics. And there has been, you might call it, a turn to ethics in the last few years, in which the concept of ethics, ethics panels, ethics groups, ethical bodies, and so on are springing up all over the landscape like mushrooms overnight. And one has to think, well, what is that all about? And why is there that turn to ethics? How does it relate to the question of law? How does it relate to other kinds of regulation? And also, in my presentation, I was going to look at the GDPR and see the extent to which it bears upon that question, because lots of the principles within the GDPR, just like with most data protection legislation, are founded upon ethical precepts, but now these seem to be coming to the fore as things of their own right, not just the underpinning of laws. And so I was exploring those kinds of developments and looking particularly at the ideas of transparency and accountability as being ethical precepts which stand on their own, even if they weren't mandated by law. But that's as far as I can tell you in a very brief 2 or 3 minutes. But as I say, I'm very sorry and I apologize that the time has run out on us. And if anybody wants to read a fuller version of it, which is not for citation, then please get in touch and I'll send it to you. Thank you.
Thank you very much, Professor Raab. And I think that's the most, I am very sorry for that, because actually, and for the audience, because I've had the chance to read this contribution, and it's an excellent contribution which would actually round up our panel and put the whole thing into perspective as we've intended to. But Professor Raab is being very humble and nice, and also giving you the possibility to engage in discussions, and I will thus give the floor to the audience.
Hello.
Ah, sorry.
Hey. I have a question, especially to Professor Raab, maybe to give him some time to elaborate on this, because I have an alternative explanation why all this ethics discussions sprung up. Corporations love talking about ethics because they entail no sanctions. It is, it's, if you talk about law, it's, about you have to pay, you have to, all this, but ethics is a wonderful topic. So I'd like to get your view on this. I studied philosophy myself, so I'm not bashing ethics here. I'm just thinking that ethics is maybe the wrong thing to use when we talk about companies using data protection laws or not.
What I would say to that is far earlier than the current spate of ethical, development, if you like, in this field. And you can see this in my paper. An American sociologist called Gary T. Marks produced a paper in 1998 or 9 called Ethics for the New Surveillance. Marx is hardly a company stooge, and he was talking about the need to have ethical underpinning of whatever kind of data protection and other laws there are, because it goes far beyond data protection or information privacy into other implications of technologies for human rights, for fairness, for other kinds of human values. The other thing I would say is that it isn't simply companies that are involved in this, but also parts of the scientific community, parts of law enforcement community, and parts of governments, at least in my country, which is the UK, who are going down this line of setting up ethical boards and ethical panels and so on. And I happen to be involved in those, some of those developments, and so I wouldn't want to see this as an evasion of sanctions and so on. It has to do with some genuine concern that people have about whether they are taking the right decisions, which is something different, maybe different from taking the decisions that will get them out from being accused of breaching the law. So I take a broader view of what this ethics thing means. I may be deluded, and it may be all total bullshit, but it may be bullshit, but not total bullshit.
Hi, my name is Catherine O'Keefe, and this is a question to the panel in general. There's a word I haven't heard yet today that I was actually surprised I haven't heard yet today, particularly in a context of ethics and the risks to the rights of individuals, the human beings whose data we're processing. Where is risk coming into this? Where do you see risk in this situation, considering GDPR is a risk-based regulation?
Shall we start one by one, Mathilde? Maybe
we'll collect one more.
Yes, maybe but if I can say a word to that, I'm not really sure. Sorry. Yes. Let's first skip the.
No, you go.
No, go ahead.
No, you.
Okay. There's a risk. There's a risk.
This was. Thank you for bringing this up, because it's actually also part of the perspective that we need, and this is also to some extent what I meant when I said the collective effect that the CNIL, for example, mentioned as well, because it relates to the risk, but not potentially what we need to clarify. It's the fact that it's not an individual, but indeed this collective risk to our rights and freedoms. And one interesting thing that I thought about, well, not only me, Okay, it's something that I read also in the CNIL report, was with regard to AI, artificial intelligence. Should we perhaps, maybe we need to have this, not dialogue only how to regulate AI in terms of how to write the code and so on, how to have accountability and explainability, but potentially also where in our society do we want to have AI? Maybe we don't want to have it in all realms of life. Maybe there are sectors which can be extremely sensible. We can think about military, we can think about education, we can think about, to some extent, some medical areas where we might want to decide and we might want to ponder upon the idea whether we actually want to have AI or ban it altogether. And I will give the word to Professor Raab.
Thanks. Call me Charles. Thank you. Yeah, there's been quite a bit of debate, and I'm sure you know about, well, are we turning in the GDPR from data protection or privacy, information privacy, as a fundamental right, or simply as something which is subject to risk analysis, in which case if the risk is thought to be below a certain threshold, then it's not really quite so serious. And I'm not sure where I stand on that. Certainly risk is written through quite a lot of the directive, not the least in data protection impact assessment and its predecessors, privacy impact assessment, which have at their fundamental core a kind of risk analysis. There was an attempt a few years ago to try and say, well, we need to have a kind of harms-based data protection regime. That is to say, if a certain information practice or a certain technological application caused harm, then that was the thing you should go for. And that would be something separate from whether it violated some kind of legal right, human right, or whether indeed it violated some kind of ethical precept, even if you couldn't show that there was some sort of harm. So these things, I think, are still fluid, and we might see that further development of this, but it all depends partly depends upon how we look at risk analysis and risk assessment, and whether those are robust instruments for determining the legitimacy or the legality of a particular action. Would we all agree on a risk assessment if we all had to make separate assessments behind separate closed doors and separate cubicles, and then come out and say, yeah, we think this, I think this risk is high, oh, but you think this is low or medium, then where do we go from there?
Thanks, Charles, and with that also thank you to the audience, because you used the opportunity to get out some parts that you will also be able to read more about in his contribution, which is indeed also, I know it, very valuable, as I indicated. I think one thing has become clear in this panel, and that's why we tried to also give it the diversity. Where the question about ethics gets especially relevant is where technology comes in. So if we use technology, if we use, now I've learned, not automated, but autonomous, the question is even more so, have we put the right decisions in place? And I think we got some quite good inspiration on where we can find that in the text, but also where there is this underlying feeling that we need to take ethically sound decisions. I would like to ask you to join me in a round of applause for the speakers. I thought every contribution was excellent, and also the only answers to questions which put together also make up a presentation. And if you have more questions, it's coffee break now, so you can maybe talk to the panelists. Thanks a lot.